Hi, this is Keith Davidson at Albertson & Davidson. In this video, I want to talk about how do you protect a parent who you think is being abused by a trustee of the revocable trust or some bad actor. You might think that your parent lacks capacity to be able to manage their own financial affairs, or perhaps you think that they're subject to undue influence and being manipulated. The problem with revocable trusts in California is that while the person who has the power to revoke, meaning your parent, while that person is alive and has capacity, only the parent has a right to take actions against the trustee or against the trust. You might be a named beneficiary who's going to receive assets after your parent's death, but that status as a successor beneficiary does not give you any rights to take action now. It only gives you rights to take action later once the trust becomes irrevocable, which is usually when a parent dies. So what do you do to protect the parent now? Well, unfortunately, about the only way that you can do it is to go in and file for either a conservatorship action or for a determination under the trust document that your parent lacks capacity. Whether you do conservatorship or the trust action, you're going to have to go into court and you're going to have to allege to the court that you think your parent lacks capacity or is subject to undue influence. Now, this may not be surprising to you, but a lot of parents don't like to be told they lack capacity. They find that a little insulting, or they don't like to be told that they're subject to undue influence because they think they're not. And so the minute you go to court and you tell the court, my mom or my dad is lacking capacity, your mom or your dad's not going to be very happy with you. And that means that if they do have capacity, your mom or dad can change the trust, because if they still have the power to revoke the trust, they can also amend it and they can disinherit you. So what are you to do as a child? Do you risk being disinherited to try and save your parent? Or do you sit back and let the parent be taken advantage of and think, well, I'll only take action after my parent dies once my rights vest under the trust document? It's not an easy decision and there's no right answers. If you are going to go into court on either a conservatorship action or a trust action and claim that your parent lacks capacity, you had better be right. So that means you want some good evidence of dementia, Alzheimer's, hopefully some sort of a medical declaration from the doctor that supports your contention. Because if you go into court and you are right and the court says, yes, there's a lack of capacity here, then you'll be given the power to be conservator, or you'll be given the power to be successor trustee if you're named a successor trustee, and no amendments can take place once there's a conservatorship or once there's a determination that your parent lacks capacity. But if you go into court and you make those allegations and you're wrong, and the court says, no, we don't find a lack of capacity, well, then you have a real problem on your hands, because not only are you not going to be able to act for your parent, but you're probably going to be disinherited when the parent gets mad at you for having taken that action in the first place. Again, these are not easy decisions, and so I strongly recommend that you talk to a lawyer, think about what your options are, talk about what the costs are going to be and some of the consequences, and think to yourself, what evidence do you have that a lack of capacity exists in your case? Because you're going to need all the evidence you can get your hands on.